let's call the meeting to order, and we will begin with the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, good morning, everyone. It is September 25th. This is the Shawnee County Board of County Commissioners work session. I'm Aaron Mays. I represent District 3. On my left is Commissioner Bill Rippon. He represents District 1. And on my right is Commissioner Kevin Cook. He represents District 2. Good morning to both of you. Good morning. We've got our County Councilor, Rich Eckert, at the far end of the desk down there. Good morning, Rich.
Good morning.
All right, so Kyle, we're really going to do it this time. We're going to have our County Councilor's office give a presentation on Home Rule Resolution HR 2025-2.
Okay. Thank you. Good morning, Commissioners. Kyle Edelman, Assistant County Councilor with the County Councilor's Office. This is a first reading of a Home Rule Resolution which would amend certain portions of the Shawnee County Code. If you remember, we codified a lot of our home rule resolutions in a county code that people can find online. This would amend primarily the nuisance code provisions of that county code. There is one, I guess section 1 deals with the general penalty provision, but primarily what we're talking about is the nuisance code provisions. So unless there's any questions, I'll just go ahead and get started.
Go ahead.
As I mentioned, section 1 would amend the general penalty provision of the Shawnee County Code. Primarily, the function would be to remove the possibility that a violation could be punished by jail or imprisonment. As I was reviewing it, I noticed that that was still in the code, so this is just removing that as a possibility. Just as a refresher, the general penalty provision only applies if if a specific punishment isn't spelled out in the code. So it doesn't actually deal with the nuisance code provisions. It's just, as I was reviewing the code, I noticed this was still in there as a possible penalty, so I went ahead and removed. So the function of this would be to remove that as a possibility. And so there's the three possibilities that would remain if the commissioners approve the resolution. Sections 2 and 3 would amend the code to make clear that it is a violation of the code to maintain and or permit a nuisance on all properties within the unincorporated portions of Shawnee County. The definition of a nuisance would remain the same as currently defined in section 23-27. I think it's important, we wanted to highlight that the Shawnee County Code regulates public nuisances and not private nuisances. Public nuisances are unreasonable interferences with the right common to the general public, and we regulate those under our police powers. So because they impact the health, safety, or morals of the community. Private nuisances are the invasions of individual interests in terms of your use or enjoyment of your own private property. I think it's important to realize those can often overlap, meaning if someone's dumping sewage into a waterway, that could be both a public and private nuisance. Whereas, if someone is doing something on their property that only impacts someone's enjoyment of their own individual property, we're not going to be involved in that. It doesn't impact the community at large. It doesn't. It's not a safety issue, if that makes sense. Section 4, it would amend the code to create a rebuttable presumption that a nuisance exists if any of the enumerated conditions are found to exist on properties in the county. I did want to highlight this presumption would only apply to parcels in platted subdivisions or parcels of 4 acres or less with a residence or that are adjacent to a residence. It would also add or make the presumption applicable to any structure found to be unfit for human occupancy or any condition that poses an immediate threat to the health and safety of the public. And both of those sort of terms or phrases are defined. Section 4 would also remove the reference to abandoned vehicles currently found in section 2330, which would make section 2332, as well as the definition of abandoned vehicles in section 2327, the only provisions dealing with abandoned vehicles. I think the purpose of this section is we had what I took to be a presumption in the code previously, but then it wasn't clear that that's what the section was doing, and it also had a random sentence dealing with abandoned vehicles. So this would strike that sentence and makes only certain sections deal with abandoned vehicles, and also make it clear that that's the function of this section, is to make a presumption that if the health department or any of our code enforcement officers or law enforcement officers find certain conditions on a property, there's a presumption that that condition is a nuisance under the code. Yep.
Kyle, what's improperly stored vehicles? What would be an example of that?
So that's actually going to be in section 6. I can go ahead and go forward to that. So
Oh, you don't, if we're going to
no,
carry.
it's okay. So section 6 is what would handle improperly stored vehicles. So any vehicle improperly stored for a period in excess of 30 days. So it would apply to rusted, wrecked, junked, partially dismantled, inoperative, or abandoned vehicles parked, stored, or left on a property for more than 30 days unless it's enclosed in a building surrounded by fence or natural objects so it's not visible from a public roadway, or it's kept on racks or blocks at least 18 inches tall, or is stored on private property by a lawful business or commercial enterprise and the storage is connected to the business. So towing, wrecking companies, that sort of thing, or junkyards. Does that answer your question?
Yes.
Bill? Okay. And I think a lot of, oftentimes we'll get calls from people saying, hey, I can see from my property my neighbor storing, inoperative vehicles or wrecked vehicles, but if they're not visible from the roadway, that's permittable under the code currently, and this would just carry that forward. So we're not changing anything in that regard. But we do get a lot of calls. I think the health department can back me up on that, from people who say, hey, it's an eyesore to me. I can see all of these vehicles in their backyard, but if it's not visible from a public roadway, it's not something that the code would handle. I'm trying to think. So this would section 5 would just amend the code to make clear it's a violation to maintain or permit a structure that is unfit for human occupancy to be or remain on the property. The same definition regarding unfit for human occupancy would carry forward from section 4. So section 7 would repeal the current section 2333 and replace it with a provision pertaining to notice of a violation. So essentially, this section would create the county counselor's office or the determining agency. Primarily, that would be talking about the health department, would have the discretion to issue a notice and grant reasonable time to cure any violation that's found on the property. An exception for emergency circumstances would be present. Essentially, because, sort of skipping ahead, we're repealing the provisions of the code that dealt with administrative hearings. So as it currently stands, the health department will send someone a notice and say, hey, we've determined you have a nuisance on your property. If you would like to appeal our determination, you have 10 days, I think is what it is, to appeal that. And then we're obligated to convene some sort of administrative hearing. We're repealing those provisions. So this is essentially a way to sort of do the same thing. They just won't have the right to have an administrative hearing. And I'll explain kind of the rationale behind that currently. But my thought on this section was, if we're repealing the notice provisions as they currently exist, perhaps we should have something to sort of backfill that, or do the same thing just in a different way, if that makes sense. So section 8 would repeal the current section 2334 and replace it with new enforcement or penalty provisions. Essentially, it establishes a fine schedule for violations, but would also allow the county councilor to file civil actions seeking an injunction, abatement by injunction, or other civil relief. The primary change here is the fine schedule. Our current nuisance code does not contain a fine schedule. We don't run them through the district court like we do all of our other code violation cases currently. This would essentially set us up to do that. And then section 9 would repeal the remainder of the nuisance code. As I mentioned, that's primarily a repeal of the administrative hearing procedures. The Kansas Court of Appeals in 2012 essentially ruled or held that counties don't have inherent authority to enact self-help or administrative remedies for nuisance abatement. So since that ruling came out, we've essentially we haven't been enforcing those provisions. We've been giving people notice, and if they request a hearing, we've been having a hearing, but those are kind of perfunctory. The administrative hearing officer doesn't really have the authority to order them to abate the nuisance or do anything. In that way, they can't find that the nuisance exists, can essentially tell the person that they're finding the nuisance exists, but that's the extent to what they can do since that ruling's been on the book. So we're essentially repealing those administrative hearing procedures. I'm trying to think. I will mention, so counties, the ruling did say that counties need explicit authorization from enabling legislation to enforce self-help procedures or administrative remedies. Certain counties do have enabling legislation. I think it's Riley, Sedgwick, Reno. There might be one more that the legislature has granted. Those are usually, from what I can tell, most of those require a prior conviction, so you have to run them through your code court, and the person has to have and the court has to have found that the nuisance exists, and then you can run it through an administrative remedy procedure. And all of those statutes have a sunset provision. I think they generally sunset after 3 years. My recollection is that all of those were renewed last year by the legislature, so they'll expire in 3 years. Okay, I think that's all I had. Again, this is a first reading, so we will need to have a second reading at some point in the future, but if there's any questions, I'll stand for those now.
Questions?
Mr. Chairman.
Yep.
Kyle, just to make sure that we are not going to be taking up any issues related to dogs or dog leash laws.
No, not.
We are not taking up any issues related to noise or noise regulation.
No.
We are also not, you see, I think those are really anything related to guns or firing of guns.
No.
Okay. Those are the three things I get called the most about, and the most unwieldy, I think, to actually have regulation of.
And that sort of goes back to our public nuisance versus private nuisance distinction. I mean, if someone's firing off weapons, unless they're violating a state law, that's impacting an individual's use or enjoyment of their own individual property. It's not something that we would regulate at the county level.
But all three of those could be violations of state law that the sheriff's office could take care of.
Certainly, yes. If it's unsafe or they're firing, I mean, obviously if they're firing in the direction of a home, that's something the sheriff's office would address.
All right. I just want to make sure that we're clear on what the code is not addressing. Because those are, again, the top three that I get complaints on.
But if it's just junk in general, that's covered with this. I mean,
Yes, yeah, I mean,
not necessarily old abandoned vehicles, but just,
yeah, and certainly if
Junk.
the abandoned vehicles are visible from the road, and they're causing, the
Yeah.
big issue with that is harborage of vermin or rats or things living within the vehicles that are spreading onto other people's property. That's obviously a public hazard that we need to deal with, if that makes sense.
Okay. Any further questions?
I have two comments, Commissioner.
Please.
Kyle and I both have talked with Judge Everts, the chief judge, about this, and we'll continue to have those conversations and figure out how we're going to do this going forward. And the other thing is that the entire time I've been county councilor 1.0 and 2.0, the nuisance code has been a constant struggle. And I do want to compliment Kyle a great deal for undertaking this task and getting this into a much better form. So he's done some really good work here.
All right, great. Any other comments? Okay, thank you, Kyle.
Thank you.
Appreciate it. We'll look forward to going through this one more time.
Okay.
When will we have the second? Will that be Monday or?
So Susie had talked about putting it on our next agenda, I believe, so.
Okay.
Well, it might have to be, let us look at that. It might be a week from Monday.
Okay. Well, we'll figure it out. It'll be soon. And probably don't need quite the level of detail the second time through, I would guess, but yeah. Okay, so that brings us to our next order of business, which is public comment. Any members of the public wishing to speak? I didn't have anybody signed up. Okay, let's go to administrative communications.
Good morning, Commissioners. Angela Lewis, Director of Administrative Services. Open enrollment will be upon us very shortly. It will start October 13th and run through October 26th. Our meetings will be October 13th at Reynolds Lodge from 1 to 3, October 14th from 10 to 11 at the ADC, that's the DOC, Adult Detention Center lobby, and then from 1 to 2 in the Adult Detention lobby. October 15th from 9 to 10 in the courthouse basement, sub-basement actually, the classroom down there. And then the 16th, we'll have it at the North Annex from 6:30 a.m. to 9:30, and October 17th from 9 to 10:30 at the Health Department, and then from 1 to 3 at the Law Enforcement Center. Just as a reminder, if you have an FSA, HSA, or dependent care spending plan, you do have to go in the system and sign up again. You have to go through the whole process. If you don't, there is a button you can push to have what you had the previous year. I'd be happy to answer any questions you may have.
Questions? Seeing none, thank you.
Thank you.
Any other administrative communications today? Commissioner Rippon?
Nothing to add.
Commissioner Cook? Nope. Okay. Nothing really from me either, so we will move on to our next item, which is executive session. We do have a need for an executive session today, and so I'll make a motion that we go into executive session for consultation with an attorney for matters which would be deemed privileged in the attorney-client relationship. Specifically, this is going to be for contract negotiations on the Maynard Conference Center Management Agreement. Did I do it right?
Yes, sir.
Okay, so that's my motion. Is there
Second.
a second by Commissioner
How
Rippon?
much time? Did you say time?
Oh, I didn't say how much time. How much time do you guys think we need on this? 20 minutes, 30 minutes?
Let's split the difference, 25.
Okay, we'll go 25 minutes, and we will begin at 9:20. So we will be back at 9:45. We have a motion by Commissioner Mays and a second by Commissioner Rippon. Those in favor say aye. Opposed? Motion passes 3-0. We are headed to executive. All right, we are back from executive session. No action was taken, and we are adjourned.